On Monday, the state's high court dismissed conflict of interest charges against 5 former city pension board members. The case against a 6th former board member may still proceed. We asked San Diego City Attorney Jan Goldsmith whether people should be allowed to sit on boards that make decisions which could benefit them personally. And here's what he had to say.
I'm not a great fan of having board members who participate in decisions that they may have some benefit in, but it's inherent in our society that whenever you have a city council or a board of supervisors or a school board, you're going to benefit or be or have some detriment arising out of decisions. If I'm on a school board and I have a child in school, I'm going to have some. It's going to have some effect. As a city council member, the quality of life. So those type of general things, I can't disagree with. That's how we govern ourselves. We have to make sure that we hold people accountable, and if there's anything specific, for example, if they own property across the street from the land use decision that's before them, then they ought to recuse themselves. The term 1090 has been thrown around, and people have been accused of crimes. It has a major importance to San Diego. I don't think it will affect our pension issues one bit, one way or the other. But it kind of brings back an old wound, and the scab's lifted for a few days. For those of us in public law, it gives some definition and some meaning by this highest law of our court in our state, and we appreciate it, because I no longer have to tell council members or board members that, the law is a little uncertain on 1090, and here's our best shot at the opinion.
Joining me now to discuss the ruling and its implications for San Diego is John Warren, editor and publisher for San Diego Voice and Viewpoint. Well, John, you heard what the city attorney said, but first let's understand, why did the justices throw out the conflict of interest charge, although the 5 former board members clearly benefited from a pension increase?
Well, it got before the court on a procedural issue, because you have substance and procedural issues at law. The district attorney found that there was probable cause based on their interpretation of another provision in statute, section 995 of the Penal Code. And what the court said, in effect, was, we're not going to go forward with this. We're going to petition. The Supreme Court says that the petition which came to us asking us to set aside this action was indeed in order, because there was no conflict in the context of 1090, as Jan just made reference to. There was an exemption for these 5 people because they fell into a greater class of 20,000, and they didn't benefit directly in the context of a conflict of interest.
Okay, but Jan Goldsmith did say this is kind of going to make his job easier. It's now defined. So what does constitute conflict of interest?
Well, that's a good question. The way the statute is written, where they can identify a benefit, such as in the case with the 6th person who has to go to trial,
Ron Satoff.
They identified how he would benefit salary-wise. But the conflict goes back to the old common law principle that says you can't serve 2 masters. And so if you have an interest and you're serving, then that's a conflict. What Jan does is speaks to the exception that's found that the court went to, which said there are some things that are so much a part of what we do that people are allowed to serve, even though there appears to be a conflict, and we will exempt them and say that their service is not conflict. This is the clarity that he was making reference to, that he now has based on the Supreme Court decision.
All right, so now what implication does this have for boards, commissions, councils now throughout the state in terms of discouraging those officials from making decisions that would benefit themselves?
Well, I don't think the discouragement goes so much to the individual office holders as it does to the prosecuting entities, which are now forced to go beyond just looking at Penal Code Section 995 saying there's a conflict, therefore we're going to bring charges. Now they have to look at what the exemptions are and whether or not the service is consistent with the exemptions laid out in the court's opinion. That's the clarity that it brings to the state, and that's the extent to which I think Jan makes reference to everyone benefiting.
All right, now, but these 5, are they off the hook now?
Well, no, they're off the hook in terms of the procedural issue that stopped them from going to trial, but they're still facing federal charges in terms of fraud, the SEC, and the very fact that the federal government set aside their cases, set them in abatement until after this Supreme Court decision. So we don't know what the impact now is going to be in terms of the federal charges that they face of fraud and some other issues.
These justices that made this decision, there are 7 of them. 6 of them were appointed by Republican governors. 1 was appointed by a Democratic governor, Jerry Brown at the time. Do they have a characteristic? Would this be considered a conservative court versus a liberal court?
I think this court on this issue would be considered a court that has looked at its duty as the highest court in the state and has decided based on law and not politics what is fair and equitable in terms of the laws of the state and the people involved. And I think that overrides who appointed them and what particular affiliation they might have had.
But it makes us take a look at what the courts are doing. We just had a kind of controversial ruling by the United States Supreme Court, which allows corporations to participate in political campaigns without limit to how much they can participate. And during a State of the Union address, the president said he was going to look for some kind of law to bring that under control. Might there be some kind of a state law passed that would make conflict of interest more rigorous?
Well, because of our check and balance system, the Supreme Court is the highest courts in the land of the state. They will rule on the law, but the Congress and the legislative body, in this case the state legislature, they always have the right to make law. And so when they're in a disagreement with the court decision, they can make law legislatively to override that. What we have to do is wait and see if that becomes an issue in California.
Okay, well, thank you very much, John Warren.
Thank you.